Good evening, everybody. Ciao, buonasera. Bonsoir. I'm Pietro Paganini, and I'm going to be the moderator today and to this, I would say, full room and beautiful event called the EUDR in practice between ambition and feasibility. So I think we will focus our discussion around, of course, the EUDR and around the fact that it should be put in practice, and then the two keywords of the day, that one is definitely the ambition of the regulation, and the second one is the feasibility. Before starting, I want to thank our two hosts, MEP Singer, thank you very much, and then Mr. Fiocchi, Pietro Fiocchi, like me, Pietro, so we have two Pietro in the same room. And of course, I want to thank Luisella and the entire team of the European Food Forum for hosting this event, and as usually as I do, also the European Parliament for the hospitality. And in a time of uncertainty, a place like the Parliament is often taken for granted, but it's the best place for discussion and conversation and sharing ideas and different views, and then also reaching the conclusion to enhance the level of democracy and the open society. The topic of the EUDR, as you know, has been extremely controversial, and also is one of the probably the most also important in terms of impact regulation, particularly when it comes on the environment and in the sustainability. And he has generated definitely a debate and a discussion that is still going on, and that's probably why we're still here. But today, I think we have to focus on one crucial question, that if the EUDR is one of the most ambitious regulatory initiatives adopted by the European Union, and certainly the most debated. So the question today is simple, and is how do we preserve the environmental objective that is in DNA to ensure legal certainty, proportionality, feasibility, and of course, I will add the word of competitiveness. And we look at today at this from three different perspectives. One is the perspective of the European Commission and the fact that the European Commission is trying to make this an effective regulation. Second, the so-called preparedness by the member states and how the different authority in the countries, and today we have at least two countries being represented, are adopting receiving and adopting the regulation. And third perspective is the operator, being small, medium-sized companies or being big companies, how they are preparing to implement the regulation. Some are definitely ahead and already implementing it. Some are behind, and in some cases also complaining it. But without any further doing, let me pass the floor first to our two host MEPs, and I will start, if you allow me, Mr. Fiocchi. Ms. Singer, please. The floor is yours, and after your two talks, we'll start with the conversation. Thank you so much.
Thank you very much. Dear colleagues, dear speakers, ladies and gentlemen, it's a pleasure to welcome you in the European Parliament today, together with my colleague Pietro Fiocchi, for this European Food Forum exchange on the EU deforestation regulation in practice. I would also like to thank the European Food Forum for organizing this discussion, and all our speakers for joining us today. The title of our event is very well chosen, the EUDR in practice between ambition and visibility, because this is exactly the point we need to discuss. The objective in the EUDR is important. We all want to fight global deforestation, strengthen transparency in global supply chains, and ensure that products placed in the European market are not linked to the destruction of forests elsewhere in the world. But good intentions alone do not make good legislation. For me, the central question is, can this regulation work in practice? Can it be implemented in a way that is legally clear, administratively manageable, and proportional for those who have to apply it? And here, many questions remain open. The EUDR has already been amended and postponed more than once. That alone shows that the original designs was not ready for practical implementation. The latest changes mean that large and medium-sized operators will have to apply the EUDR from the 3rd of December 2026, while micro and small operators will follow from the 3rd June 2027. Some simplification measures were introduced, but they do not solve the core problems. On the 4th of May, the European Commission published this simplification review, updated guidance in new FAQs. This was expected to provide more clarity and relief for operators. However, especially from the perspective of agriculture, forestry, and smaller structures, the result is disappointing. The Commission has clarified some points, but many practical difficulties remain. In several cases, existing obligations are confirmed rather than made workable. This is particularly relevant for forest owners and for forestry associations. In many member states, including Germany, we have a very fragmented forest ownership structure. Many forest owners manage small areas and work through forestry associations or cooperatives. These structures are essential in practice, but under the current approach, these associations still cannot submit declarations collectively for all their members. This risks creating countless individual registrations instead of using existing and trusted structures on the ground. This is the issue of geolocation remains highly sensitive. In practice, many forest owners will still need to provide detailed information such as cadastral data or GPS coordinates. For many small forest owners, this is not a minor technical detail. It is a real administrative burden. This is why the discussion today is so important. We need to hear from the Commission how it intends to ensure legal certainty and practical implementations. We need to hear from the member states how prepared their national authorities are and whether implementation will be coherent across the EU. And we need to hear from the operators in different supply chains. Some are already advanced in implementations. Others are facing complex value chains and serious practical challenges. For me, one point is clear. The debate should not be framed as a choice between ambition and visibility. We need both. A regulation that is ambitious on paper but impossible to apply in practice will not strengthen trust. It will create frustration, uncertainty, and unnecessary bureaucracy. At the same time, a pragmatic implementation does not weaken the fight against deforestation. On the contrary, it makes the regulation more credible and more effective. I personally therefore believe that we need a more differentiated and risk-based approach. An additional very low risk or zero risk category could help focus controls where they are really needed to reduce unnecessary burdens where the risk is demonstrably very low. This is especially important for European farmers, forest owners, and SMEs who already comply with strict national and EU rules. They should not be treated as if they were part of the problem where they are already part of sustainable land management. Our task as legislators must be to ensure that European rules are not only well intended, but also workable. I therefore hope that today's discussion will be honest, practical, and solution-oriented. I look forward to the contributions of our speakers and to a constructive exchange. Thank you very much.
Thank you very much, madam. We can give applause. I know in Brussels, many applause. Before passing the floor to Mr. Fjock, I'm sure we are in a bubble in Brussels, so I don't have to repeat what the EUDR is and how it works, because I'm sure all of you, and that's the reason why you are here. So we understand the DNA, but as an Italian, I was noticing you were shaking your head and look at very much a gesture and long breath. So I'm sure you have some good points or bad points, depending. The Commission is sitting next to you, so just inform. Floor is yours.
Thank you very much. My colleague Singer already thanks everybody, so I'm fine with that. I have to remember, but also our old colleague, Nida, that left us for a government position in Germany, but she was at the start with us. Deforestation, if it wasn't true, it would be a comical history. I mean, I'm following it for probably the last 3 or 4 years. It was delayed twice. In the beginning, there was discussion that if you were an importer in Europe, you should use satellite data to prove that there was no deforestation from your customers, and some crazy ideas like that. Then the Commission did something not very nice, but we caught them, because they said that all the other countries around the world were informed about deforestation laws applied by Europe. And so I called my friends at the farmer organization in the US, in Chile, in Argentina, and in Canada. And they had no idea what the European Commission was doing. So I was like, are you sure that you talked to them? Well, maybe later. No, maybe later, just a second. And so we had a postponement, another postponement, and so on and so on and so on. And this is the second one, which is also comical in my opinion, because they didn't want to do a stop the clock, but they did a postponement. And they say, okay, micro small enterprise, 12-month delay. On the medium and big enterprises, no delay, but we're not going to control what you do. Like, okay, let's go on. You know that also initially they published a list of the countries with high, medium, low, or zero risk. And one of the things that we ask is like, if you are low or zero risk, you should not be mandated to certify to have bureaucratic cost regarding deforestation, because your country has no risk. They say, yes, you're right, but in any case, you have to register. So anyway, they like bureaucracy. Now, what we are discussing right now is obviously another postponement, not because we want to avoid this. Again, we are all for fighting deforestation, but we need to put together a system which will not put the European enterprises in a negative situation regarding the level playing field with other companies outside Europe. So we're still pushing for another postponement. We're pushing for a further simplification. And we are also pushing, because on this one, the Commission was not very clear, but our suggestion was that if you have a first importer in Europe, then what is the reason of requesting the same type of paperwork from all the other companies in Europe buying from the first importer? It should be also the first importer doing all the paperwork, and then stop. We are in Europe. We certified there was no deforestation. We should stop asking for more paperwork. Okay. Then we're also asking for taking out some of the products and everything else, in particular, the printed one and so on. But some things has been done. The frequent ask question system on the Commission website is okay. The electronic system is okay. It's getting better. The Commission is guaranteeing that the application will be totally effective by the end of this year. I have my doubts that this will be the case, but whatever. Also, by the way, when we're talking about, sorry, I forgot about this, when we're talking about excluding some of the products, we are looking, for example, at soluble coffee or tires or whole bunch of other products which would be very difficult to trace and certify. And we hope that the Commission will listen to us. Generally speaking, as it is right now, this package, EUDR, is negative for the European industry. So we need to fix a lot of points so that, yes, we fight against deforestation, but we do not kill European economy and jobs. That's it. Thank you.
Thank you. So did I understand correctly, or you said another postponement?
Yes, because
Okay. So I think we can go home and come back next year for the debate.
it's nice.
Anyway, I'm opening the bets that if we want to have a third postponement. But since the discussion is already in, let's say, moving, and you mentioned coffee, we have coffee in the room, so I think they were smiling and celebrating. But now I think we deserve also fair discussion and a fair debate, and competitive as well. So we're entering the competition. So I will leave the floor right away. And as moderator, my goal and my objective is to at least limit myself and also limit the time of every speaker. So all of you have a precise time, and I will try to make sure you respect it. People that know me knows that I never respect time myself as an Italian, but I will try to make sure others are respecting it. So I'll leave the floor for your answer at this point to Mr. J. Sazens, if I pronounce correct. That is the deputy head of the cabinet of Commissioner Jessica Roswell. So I think is the best person to tell us if we're going toward third postponement, so we can open the bets.
Yeah, thank you very much. Buonasera, guten Abend. Well, if you expect me today to bring you that news, then I have to disappoint you. But if you expect us to bring maybe the news that we need to, as Christine Singer, as you said, to work towards a pragmatic implementation of the EUDR, then I think we can be and will be a very strong, actually, and reliable partner on this. And I think that's the journey in that we are on. I think we maybe to start a bit with, I'll briefly also comment on the objectives we are pursuing, and then maybe briefly recall a bit what the simplification steps are we've been doing. But I think many of them were already mentioned, because this is really also I would say co-creation of the co-legislators and the European Commission. And we've worked on this, and I think in part, I would say to a certain significant part, also thanks to of course, the boots on the ground which exist in this house, and the many people you are calling, and the checks and balances. I mean, that has certainly helped over the past 2 and 3 years to find out what were the flaws in the law initially, because I think those flaws clearly existed. Otherwise, we would not have needed to actually improve it a couple of times. Still, I think the objective is clear and shared one. Forest loss is a big international problem, and it is on the rise again in the recent years, basically. And agricultural production, and we know that all, you know that also from the sector, is one of the biggest contributors, around 70% of indeed the driver of deforestation. So it is clearly, I think that is a shared point. It's a common objective to make sure that indeed Europe also, let's say, limits its contribution to deforestation. I think it's also clear that any response we are providing needs to be proportionate and pragmatic. I mean, you know that this commission started with the objective to reduce administrative burden significantly, 25%, 33% for small companies. In this on this particular file on deforestation, we also have taken this seriously. I think we have now provided simplification about 75% of the burden compared to the laws as it initially stood and was initially agreed by the co-legislators. So I think that is quite a significant step, but those are also steps which were necessary indeed to, let's say, make this law manageable. And again, I thank the Parliament and also the member states and the Council actually for, let's say, healthy pressure and pragmatic work on this. Just to recall a bit where we stand now, basically. We have done several steps of simplification, 2 changes indeed of the law, a broad set of guidances and frequently asked questions. Those are not product just of the Commission, certainly also of the European Parliament, and the many discussions we've had here, also my Commissioner Jessica Oswald has had here, and with the member states, but also the stakeholder platform, which we are having, and to which I think a number of you also have been contributing, which has met really regularly over the past years. We have also engaged in an improvement of the ICT system, which I think was also necessary. As much as things were too complex for the operators at the beginning, they were probably too complex also for the public administration, and we needed to fix that as well. Let me just summarize maybe 4 key points where I see important significant simplifications which have been agreed over the past years, and which we've now recently clarified indeed with the further enhanced with the package we presented just now at the end of April, or rather the very beginning of May. So the first step is indeed the small farmers and foresters in low-risk countries, for whom we have indeed completely gotten rid of the due diligence obligations, and indeed included and provided a one-off registration declaration. And we worked on a number of options there, possibilities to also replace this with postal codes and other solutions. I think this is an area where I hear from some stakeholders we are still not fully there, and I think at this stage we are working, and we probably need to work with the member states as well, because the situation is slightly different from country to country. So we also need to, let's say, then together, and so I'm curious also to hear from the various authorities today. I mean, at some point, there's only so far we can have common solutions for everybody if the situation is not the same, if the data are not the same. And the question of associations, for example, we have provided openings and clear possibilities there in our documents. But at some point, we also have made clear in the document that, I mean, then we need to find the real solutions also on the ground, depending on the specific situations. But that's the first one. I think small farmers, small forest holders are indeed, I think we have had a very, very significant relief, and for good reasons. The second big one is indeed the supply chain. In the beginning, you remember that in the law, we had the full supply chain in duty. And that for good reasons, because indeed, I think the idea was precisely to also make sure that everybody in the supply chain also exercises their kind of scrutiny. But of course, I mean, if you do that once, twice, 3, 4, 5 times, maybe at some point you have too much scrutiny, and the added value becomes lower and lower. So indeed, we decided to limit this together with the co-legislators to actually the one who's importing into Europe and the first one downstream, in a way, to have one check and balances, one check for the import. But already as of the first downstream operator, this is really a purely passive obligation. So the active obligation is really on the importer, or the one who places first on the market. And after that, it is really a passive obligation to register, to collect data. And I think that's something we've also now in the recent package further clarified. I mean, for most people, this is really mainly the ordinary information which you collect in the course of your business, on your tax receipts, on your accounting documents, basically. So I think that's something we've also further clarified. So that's, I think, a quite significant issue in the downstream supply chain, which is also quite important indeed. So that was the second one in terms of simplifications. I think the third one is indeed when it comes particularly to products from low-risk countries. I think this is something which was already kind of included in the EUDR initially, that there would be simplified due diligence. And we've really made clear that it is quite operational, quite simple for people to know what that means. Because sometimes you get European documents where you say it's simple, but then in the end it is not so simple. So we have indeed, I think, made quite operational in our FAQs and the communication what are the points you need to look at. And if there are no indications for additional risk, in a way, it's really a quite limited, let's say, set of issues you need to look at. In particular, actually, the question of legality. And for that one also, we have provided additional actually support and clarified really you need to have a rough check at the repository which we're going to create. And that's it, basically, if there are no further indications. So this is indeed the set of facilitations we have for the products from low-risk countries, which of course are both the European countries and many others as well. And the fourth element I want to mention is indeed the scope. We have, let's say, put out for consultation this delegated act, actually, which also clarifies the scope and indeed also excludes from the scope some, I think, some products where, like leather, where indeed I think the balance between cost and benefit was maybe not really appropriate. Now, that is something which is, of course, still under consultation, and it will also be subject to objection in the Parliament and the Council. So we will look at the feedback, we'll consider that, and then we are curious also to hear how the Parliament will see this. But these are just maybe 4 concrete elements of simplification I want to mention. Are we going to get more delays? Are we going to get further changes? I mean, my experience in various areas at some point is that operators, there's a balance between getting it right and getting it clear, basically. And my feeling is that we are slowly approaching this balance, that we could maybe get it a bit more right. But then, I mean, the additional costs in terms of stability would be such that maybe it doesn't justify it anymore. So I think from our side at this stage, I'm sorry to apologize there or to disappoint there, we would call now indeed for stability of the legislative framework, and indeed to work really also with the authorities and with the operators to, let's say, get good and pragmatic implementation on the ground. And not last but not least, of course, to base this also on the ICT system, which has also been significantly improved with a number of additional features and also tackling some of the limitations. And so we hope also this can be a good basis now for the.
Thank you. So we see we are already having 2 different approaches. I see. I also open just a second. Mr. Fiocchi, I open also for a very quick Q&A, also because just for transparency and clarity, we have people representing different organizations, but also producing countries coming from abroad. Mr. Fiocchi earlier talked about European companies, but there are also other nationalities that are affected by the EUDR represented. So I will start with you, and then I will take a couple of questions.
No, just to clarify, I have a fantastic relationship with Commissioner Roseman. I would probably talk to her tomorrow too, but we have a rule that we cannot be politically correct, so we say what we think. But the collaboration is good. So
now the ball is again in the field. Any question for the Commission? Miriam, please. Introduce yourself.
Yes, thank you, I will. Hello, my name is Miriam Schneider. I work for the German Food Retail Association. And as you can imagine, we are not affected by just one commodity, but by many. We have 40,000 products on shelves in supermarkets. And yes, we welcome the simplification. And we think a lot has been done, but you have to imagine that every simplification goes along with internal changes of processes again. So it's a sort of a double-sided sword. It has to be implemented, and it has to be implemented with suppliers. So my question would be, you mentioned that the scope has been made lighter in the Delegated Act, but you have excluded certain products, but you also have included new products. Will there be, or are there discussions about sort of a threshold for very minimal quantities? If we talk about soaps, for instance, there are products that contain very little quantities of soaps, and they still now come into a scope where you, if you are an importer or a first placer on the market, you have to provide a full due diligence assessment, even though there may be 0.1% of soap ingredients in a hygiene product, in a little cloth or something like that. So is this part of the considerations you are making? And the second question I have is, what about the IT system? Do you think it'll work this time? I think there is a contingency plan included in the implementing act. But how can you make sure, is there a sort of a proper testing with a full-fledged use, and how to make sure it won't end up in a data flood after all? Thank you.
Thank you. Can take another question, maybe, if we have one.
Thank you, Emiliana Axiotiades, represent Coseral, the grain traders. And their voices. I will speak later, but I just have a specific question now, which is also on the IT system. I was listening also to Mr. Fior. What do you do if it falls apart? I mean, this is really the question, because today everybody says the capacity is still not sufficient. There were adaptations that were made, but I haven't personally heard a person who's convinced it's going to work so far. What also alarms me, if I may say, is that there was a report from DG Environment last August saying it was not ready. Then later we heard postponement, and despite a certain number of people being aware of the fact that DG Environment themselves thought it was not ready, the Commission went ahead with it. So just how can you reassure us? You know, because now, I'm sorry, how can we trust? You know, so how can you reassure us? What are you going to put in place? What if there are importers who find it impossible to upload all the information they have to upload? Well, that's my question. Thank you.
Thank you so much. I see a lot of hands here now, but please, very short questions. Thank you.
Yeah, just supporting the questions on the IT system, working for Mondelez, big company on chocolate and biscuits. Can the Commission, do you have an indication of when the IT system will be available again? Because we are 209 days before the implementation and we want to start testing as a company, but the system is not up and running. Can you give us a date? And then I support Iliana and Miriam on the contingency plan and the testing program that we are also waiting for. Thank you very much.
Thank you. I see a question there. Introduce yourself as well.
Sure. Thank you very much. Hello, Ali Abdi is my name. I'm with the U.S. mission to the EU. Thank you for the opportunity to be with you today. And we welcome all the effort that's been done thus far on the simplification of EUDR. I just wanted to ask, the current sort of the status of the regulation is really still very, very much places a heavy burden and in terms of cost on products from countries that are low or negligible risk countries coming from products coming from those countries. And my question is there any further consideration for further changes? Because the current the review that just happened really did not address the core concerns from countries like the US, where we have negligible risk. Thank you.
Thank you. Thank you very much. Just the question, please. Name and question.
Niall Monaghan from the Australian Embassy. There was a figure mentioned of 75% burden reduction since the initial proposal. I was wondering, did the Commission do any analysis on how much of that would accrue to third country producers? For example, if that could be separated, how much production could a reduction expect from the initial burden? Thank you.
Thank you very much. Lack of time, just a question, otherwise Jay will burn.
We don't want Jay to burn. Greg McDonald from the Canadian mission to the EU. You talked about low-risk countries and farmers in low-risk countries not having to provide de facto due diligence. But my question is for small farmers and foresters who place products on the EU market from countries like Canada, they ship them through intermediaries, so trading companies, some are present today. So how would they avail themselves to the simplifications from the December 2020 package? And my second question on downstream processors, you say it's the first operator putting on the market. So going to our forestry sector, it would be in the EU, presumably the log that goes on the market. But what Canadian forest companies and forest product companies do is put the paper or the furniture on the market. So there's a difference in due diligence requirements. How can the FAQs and guidance help clarify that the conditions will be the same for low-risk countries within or outside the EU?
Thank you. Jay, I leave the floor to you for the answers. Thank you.
Very good. Thank you very much for all the questions, which helped me to clarify a couple of further points indeed. So I think the first points were raised on the question of the delegated act and some of the exclusions and also inclusions. I mean, I think, of course, there are always several factors, let's say, which play a role here. I think you mentioned the question of soap. I think the question there is really indeed also, I mean, as in all the areas, you need to look at the whole supply chain. It's a supply chain which in some respects and for some products was already covered, but indeed we are, let's say, suggesting to extend this, I think, based on the data we have. But this is let's say, I mean, right now it's a proposal which is out for public consultation. So I would really also encourage you to make those points in the response. How is it? Very good. How is it with de minimis? I think we've provided, in generally speaking, in our, let's say, materials, some possibilities and some examples there. Let's say how you can deal with very small quantities. But I'm not saying that this is addressing necessarily all the specific areas of the soap sector. So that's why I would really encourage you also to make these points in the consultation. Then I think a number of questions on the IT system. Will it work? What about indeed fully fledged use and testing? What can we guarantee here? So I think, well, you know how it is with IT products. Basically, I think you can do two things. You develop something in iterations, and you, let's say, learn from experiences. And then, of course, at some point you put things live. There are always, let's say, risks involved. So you need to, of course, have indeed then contingency plannings. I think there's no IT project which doesn't have these elements. I think we can fairly say that we are learning from iterations, and indeed it was one of the areas we started to put the system live. We learned from the way people interacted with it, which was partly different from what we had expected and we were told before. And I think we then draw the conclusion that basically what we have is not fit for purpose. We worked based actually on the factors, the key factors which determined the problems at that time, basically. One was indeed the large amount of people who put in data. And I think, let's say, one of the simplifications indeed to take out a large part of the supply chain was a lesson from that, which will significantly reduce actually the amount of need users of the system. That is, I think, one example how we basically learned from the first testing phases and draw the conclusions, try to work on the factors indeed and improve the system on that. And I think I could give you a couple of other examples. So I think we are, let's say, confident that the system is now in a much better shape. But I mean, never say never. There's no ICT system in this world which can be perfect. In that sense, I think we also have put out in the delegated act or in the implementing act the contingency systems. So you were asking now indeed also about the next steps, and the next phases will come. There I would need to ask you for a bit more patience. We just needed to now first indeed adopt the implementing act, which is the basis for the IT system. That is something which was just kind of confirmed with the member states, and we are in the final process of finalizing this, and then basically within a very short time period, the actual implementation will then come. So I can reassure that, but I cannot give you at this stage any specific date because these procedures first need to, let's say, be implemented. So, but overall, I have the impression that, I mean, we are also compared, we of course are speaking to many other people in the Commission in different departments, basically. And I think compared to other IT systems, I think we are now in a relatively good shape. That's what, let's say, our impression was. And of course, also to others, compared to other systems, which are relatively broad as this one here as well. And then I think a set of questions indeed also from the perspective of, let's say, imports from third countries. Thank you also for those questions. Now, I mean, the one thing indeed I would want to point out is that, of course, I mean, we are not starting from scratch in terms of having due diligence obligations for imports. We have EU timber regulation, which is in place, which indeed also, let's say, in a way has for more limited set of products, but still has a, let's say, a tracing, which also, when it comes to the international part, is actually quite, it's not dissimilar. So basically, we are building here on an experience and, let's say, evaluating or, let's say, expanding it rather than inventing something completely new. Still, I think we have for low-risk countries included a number of simplifications, and in that sense, I would not really agree that we have not really addressed the particular situation of them. I mentioned a couple of them basically before, when it comes indeed to clarifying what are the very limited obligations which are necessary for those low-risk countries. I clarified also indeed what particularly I think the legality criterion is something which you need to check when you come from a low-risk country, but that is something where we have provided additional indeed also instruments and tools actually to make this as simple as possible. So I would think that we have also done a number of simplification efforts, particularly for imports from low-risk countries. How much of the burden reduction, there was a question, falls on EU and how much on third countries, I would not be able to give an answer on that, also because, I mean, if you import a product from a third country to Europe and then here it goes through the supply chain, I would not really know, I mean, should I put this on the EU or on the third country product? So that is not a distinction which we have made. How does it look for small farmers from third countries? The same rules apply to them indeed than for, let's say, small farmers from EU member states. But it is of course true that to the extent a small, let's say, a small producer sells to a larger intermediary, then in a way, I mean, that is very much in line with the distinction, the way we distinguish between small and medium-sized and larger companies in Europe and generally. Then indeed, what applies are normally the rules actually for according to the size of the company. So if the trader is a bigger company, then indeed also those rules apply, which is I think again very much in line with the general principles we apply also in other areas basically. But overall, I think we continue to work also here quite closely with indeed third countries, continue to meet and interact and see also how we can further actually address the issues and the concerns. And yeah, we continue to hear that is clear. We continue to hear differing views. Some countries who are saying yes, we are ready, and why are you even postponing? And some operators from third countries, I think some people in Europe said our own businesses are less prepared than actually third countries. You focus too much on the third countries and you forgot our own, let's say, or producers. Then of course others are looking at it from a different perspective. But I think from our side, we've really tried to focus both on the third country dimension and working closely with third countries, and continue to do that, and also on the European producers, and we'll certainly continue to do that. So it is clear that as things come into force, we will also continue to monitor and to try to learn our lessons and
Thank you very much, Jay. I think it deserves really much for answer all the question. I'm sure there are more questions, but maybe if you're staying till the very end, you will get some questions outside. I should run away quickly.
I hope you're not running away.
You can stay.
The microphone, sir.
Yes. One of, I think, question or part of the question was also the fact that there are few, let's say 200 days or let's say less than almost a semester left of testing, and then the local and competent authority or national authority in a way will take it over and will have in a way to intervene and make sure that the regulation works. And so I will definitely pass the ball to the countries, and we have two countries here who are represented, and I will start with Germany, and particularly exactly in front of me I have Andrea Schaffer from that is head of the department of the German Federal Office for Agriculture and Food. So the floor is yours, and you provide a perspective of how Germany is preparing for EUDR. Thank you.
Yeah, thank you very much, and guten Abend from Germany as well to all of you. Yeah, so very interesting to hear so far what the state of play is, so to say, and I'm happy to provide the perspective that we have and what the efforts have been so far for the German competent authority. So for the last 2.5 years, more or less, we've been preparing since we've been appointed with the EUDR controls to perform the checks in the future. So my agency actually had the task to perform EUDR checks as well. So we have that experience already, and I'm very happy to have that. And it basically goes into the preparations that we are doing right now. So what we have done is step into dialogue with all those German stakeholders that are part of their very own EUDR preparations and how they try to implement, because it was very clear to us as well that there are challenges that come along with EUDR implementation, from the very basic form of the regulation to what we have right now, is what we call EUDR 3.0, so to say, because 2.0 were the changes from my perspective, what we got in December, and now with the latest package, we are at the 3.0, and hopefully there won't be a 4.0 or something like that. So what German stakeholders also reflect to us is that as the regulations stand right now, people and everybody involved want to prepare for what is coming, and they need a certain kind of certainty in order to know what they have to do, what they have to provide in case of information to be compliant, and how to do that. And that is where our approach started. So as I said before, stepping into dialogue, knowing what the challenges are, providing information on where the legislation is and what we as the German CA will expect when performing those controls. So that was the one part. The other thing is that we have intensified through this last year is talking about enforcement, looking, so to say, at the neighboring countries and how they will approach their very own control. So talking about performing dry runs and see where companies stand. And this is something we started during this last year, and just to make sure what the approach of others is, to compare what the legal assessment is, and then see what the possible outcome is. So just to align in this, as you all know, there are those working groups on the EU level, but it was very, or still is, and will be in the future, important for us to see where we are going with those controls. So permanent information on the one side, and then what the other heavy thing that we worked on in Germany is implementing our very own system, the so-called service portal, where we will perform the controls. So German stakeholders, German operators, so everybody that is chosen to be controlled by our agency will be led to this portal that is designed to make those controls, the performance of the controls feasible, and to actually be able to provide the information needed in the most easiest way, so to say. So coming back to what has been said, we heavily rely also on the EU information system to work, because we will take all the data from there and take this as a basis for our controls, and then do our own risk-based approach on performing the controls. And this is what we've been working on. And so talking about what the state in Germany is, in my opinion, or what we have been hearing, of course, there's a very diverse scene, but the general idea is that the people want to know what the legislation is, how the regulation has to be applied, and how the German CA, in our case, or what we can do to help them. So this is our more or less practical approach, and we've been in, as I said, constant contact and developing from there, and very optimistic to be able to perform those checks coming early 2027.
So I will give the floor to Dr.
So thank you. So our competent authority in Italy has a very complex name, ICQRF Department, which is the main enforcement authority in Italy involved in agro-foodstuff controls. And since 2 years ago, also for this particular kind of job regarding the EUDR. So what's going on in Italy? First of all, we have been completing the legal structure, national legal structure, in order to establish responsibilities at local and central level, to identify sanctions, to identify also possible form of cooperation, not only for with other control bodies, like, for example, Carabinieri and so on. We have been committing very, very hard during these 3 years, more or less, with the DGMV, the informal working group, in order to cooperate, to simplify a lot, because this is the case. And in this account, we have also envisaged a sort of risk analysis before the final implementation of the information system. This is our job, because we have envisaged the possible risk analysis system based not on the information system of the European Union, because 2 or 3 days ago, we voted the first proposal of the amending regulation 38/84, but this risk analysis assessment was drafted on the ground of data and information provided by the Italian Customs Agency for more or less all the commodities included in the regulation, apart from woods, because wood is under the competence of another Directorate General. So in any sense, we are ready for checks, but we have to decide some legal points. We are working in terms of simplification in order to reduce administrative burdens, because this is the matter with our payment agency, because the Italian payment agency, in terms of providing information and so on, has got a lot of information concerning farmers and so on, including the geolocalization, because we may have a lot of layers to be inspected. And last but not least, we are keen to provide our expertise, our help to the Commission, to the other member states, in order to start working with this regulation, and also to help you to give additional simplification, if possible, during the implementation phase of the information system. Because if I remember well, on the 5, the representative of DGMV promised that probably a sort of simplification of Annex 1, if I remember well. But in any case, we are also to say that many operators and industries and so on are showing some concerns. Okay, they have a sort of a very impacting fear about the implementation of this regulation. Some has manifested a sort of concerns about the additional costs. So I would like to invite all of you to be very careful in implementing this information system, in order to cut, if possible, of course, some additional administrative burdens. This is the positive message I would like to give you. Now, you want to add something?
So a message for the Commission. Also, you made the question, simplification plus, in Italy at least, we have a further simplification. So I'm not sure simplification plus simplification makes simplification. It could make complication, but that's something we leave to figure out. But thank you very much for that. And I see also Dr. Salvatore Alberino, that is a senior officer at the Central Inspectorate of Quality and Protection and Fraud Suppression of Agri-Food Product at the MASAF ministry. So I leave the floor to you and to follow up on what Dr. Philadelphia just said. Thanks. Thank you so much.
Good morning to everyone. Well, I have nothing to say more. My chief already said everything. Just want to underline that we followed all multi-stakeholders platform, and we give our efforts and give our suggestion to make real possible this regulation. As Mr. Fiocchi said, we all are against deforestation. We would like to work, but we need to be careful to do not do something that is impossible to make in practice. It's very important, as my colleagues from Germany said, what we really need is something that is certain. There are still too much doubts. There is still too much things that are not very clear. And to be honest, I'm not sure that just with facts and like guidelines, we could find a solution. Not going to say, but if there's some question.
Thank you so much. Maybe before going back to Andreas, I leave the floor for questions, since we have the opportunity to discuss directly with the authorities, the so-called competent authorities that should inspect the products that are coming in. But Andreas, before we take questions from the floor, how do you envision this inspecting process, or when shipping are coming in, and Germany has clearly ports like Italy as a big importer as well of certain commodities. How do you envision this? Let's say it's today's 1st of January in 2027. How is this process going to work?
Thank you. So I think very important to say when we're talking about those scenarios that the general idea is not that supply chains should be interrupted or that goods should be stopped at customs. So speaking for Germany, that will not be the case, because those EUDR controls will be performed with a timely delay when all the necessary information is provided, and which basically is the reference number. So there shouldn't be much of a problem there. So as I said, leading up to those EUDR controls by us, the general idea is to have that a digitized process. As we said, or a lessening of the bureaucratic burdens mean for us that we have a digital tool in place that people can use, that they are guided through a structured process of providing those necessary information, because the idea is that all the information are already available once you produced those DDS statements. And that is what you basically need to create those in the information system. And our checks based on that, or are based on that, and of course have a deeper dive into the actual information to get to the result in the best case that there is EUDR compliance. So there should not be further information being created that has to be created, so to say, if the entity is to be chosen by the German CA for a control. So the process, as I said, will be one that is heavily digitized, led through this system, and hopefully there is the overall result that there is compliance. So speaking of coming from the EUDR experience, of course, at those early stages, there will be some sort of problems that will be faced. Non-compliance in some shape or form, this is something to be expected, but also important to say that this does not mean, and this is, I think, one of the fears going on or coming along with this early stage of controls. If there are points that are pointed out during a control of that, there, of course, will be looked at the singular case and what the breach, let's say, what the breach is. And of course, we are quite aware of the challenges, as I said before, that each stakeholder has been faced with when gathering the necessary information. So keeping that in account and this early stage of controls, of course, there will be a yeah, problems or hints that have to be given, but that does not necessarily mean that there will be legal consequences. I think this is very important to say. This is why I said we will align with those other CAs in order to have a common idea of how the law should interpret it. And I think this is the way to go in order to not raise the fear of EUDR controls being harsh in the sense of heavy fines or whatever. This will not be the case. As I said, this is speaking from EUDR experiences, and I think since EUDR is even the heavier challenge to be faced, this is something that we, as I said, expect, but are positive that this will not create problems in a way that I just described. So positively looking towards that as well, basically.
Thank you. Thank you very much, Andreas, particularly on the implementation and also on the fine side that you clarified this. I don't know if you want to add anything to this. Otherwise, I leave the room for, there are some questions here, please.
Thank you very much. Florian from COSEAL, also the EU Associations for Grain and Oilseed Trade. We are mostly vote for soy and palm oil. I wanted to pick up on your reply just now and on the concerns we had previously on the information system, and on the fact that any information system, there might be mistakes, there might be some learning curve, because that was a comment that the DG Eric Memmer said last week to the Parliament, that as of the 1st of January would be in a learning curve. You've mentioned it about the fines. I think is a big concern. What would happen indeed if your digital systems and if the information systems break down because of the amount of information coming in? What would happen if you had a big Panamax of 75,000 tons of soy coming in, waiting in the port to be controlled? And then in the end, who would have the cost of the waiting in the ports in order to get the information through? That's because there is indeed that concern of the penalty. If the information doesn't go through, who has the penalty, and then who has the cost of waiting to get the information through? Thank you.
Thank you very much. Very operative question. There's another question there.
Good afternoon, David Mills from Mondelez. Just picking up on that point that was mentioned there, and we have a system in place now about fisheries, EU catch, and your point about simplification. And I wonder, we see with the EU catch a number of issues playing out, missing data fields, PDF size issues, paperwork and backlogs. When you look at that system, what lessons can we learn from EU catch, which will run on the same architecture that EUDR will work on? It's a module within the traces system. What opportunities are there to learn from that and to simplify things?
Thank you. Other questions? One there, please.
Thank you. I was just wondering, I think it was mentioned that dry runs or trials have been taking place, maybe with some shipments in advance of the, let's say, the regulation coming on. I was wondering, have you experienced or have you dealt with any of the sort of the trading international side, and also on the domestic side, in Europe? And what are some of the areas that you see as a potential, concern? Thank you.
I think the three of you can answer. Thank you.
Oh, sorry, in case of malfunctioning of the IT system, but we have to wait the final implementation, of course, because it's too early to talk about it. But according to my previous working experiences in other IT systems for wines, for olive oil, and so on, I think that we need fallback procedures to be established at the EU level or with the consensus of the European Union institutions, to be established at the national level. A sort of gap to be full of documentation or declarations waiting for the functioning of the IT system. But this, I think that this maybe discusses with the EU Commission in a technical table, because each and every IT system in the world need to be accompanied by fallback procedures.
Thank you. Andreas, if you want.
Nothing to add to that point, basically, but I would second that. Yeah.
Any other answer to the three questions, or
Yeah.
Andreas?
Concerning this last question, the results or the learning from those dry runs. So what we have seen is interesting as regards to what the main issues were. So and what the concerns were coming from stakeholders. So at the let's say the earlier stage in the timeline, maybe leading up to the beginning of last year, the gathering of those geolocation information seemed to be the most concern and the challenge that everybody faced, and what many questions that came to us were the subject of. So there seems to have been a change or a shift in that, because I think the possibilities, the technical ones, the service providers that help with gathering those information have actually been used in the meantime. And so providing those geo information, and we looked at those as well from those dry runs, didn't seem to be such a problem. The shift that I mentioned was towards those legality requirements. So the uncertainty that came along with that, what the documentation is that needed to be provided there. This is the learning from those dry runs during this last year, that the check has been done on the geolocation, but the actual question is, okay, what is the legal information that has to be provided? And concerning that, we are very much looking forward. Of course, there have been further FAQ and guidance that have specified those fields, but those repositories that have been announced to be provided by the EU Commission, especially concerning those legality requirements from the specific countries of origin. So this is, I think, a very important point in providing a level playing field in terms of legal interpretation and what needs to be provided and what actually does not need to be provided. So very much looking forward to that in order to have this common playing field. And yeah, this is quite a learning from what we saw. So the shift, in summary, that there are the questions, or there lie those questions by now.
Bartolomeo, please. Oh, both of you.
Yeah, just some an important issue. Someone can be fined if it is recognized, he or she is recognized with a liability for some infringements. Okay, if there is a technical problem or disturbance, there isn't any liability for that specific infringement. This is why we need also fallback procedures, because also to avoid any, how to say, pirate behavior. Okay, pirate behavior from bad operator. Okay, because if we cannot demonstrate any technical problem, we can't have the possibility also to impose fines. So we need fines to be connected with the liability of the operators, together with fallback procedures, because we cannot issue fines at our will. Okay.
Just want to add a few words to
my colleagues from Germany. Yeah, we already spoke in the last multi-stakeholders platform. We need a repository for the national legislation, no? Because we cannot know all legislation from all countries. But what is important, that this repository must be very friendly to use. It's since we have to run a lot of controls, it's not easy for me if you produce legislation in China, in Taiwan, in English, I'm Italian, but English, okay, or in, I don't know, let's say in Spanish. I mean, we need the tools. This is one of the points that we spoke in the last multi-stakeholder platform. We need tools that help us to make control, and most important, control must be the same from all countries. We need to have the same instrument to make controls. That's it.
Thank you. Very briefly, before moving to because I got some more questions here to me, before moving to the other panel, but do you see any legal risk for you as authorities that companies might find themselves in a very unclarity, and then if they get the sanction, might react through a legal procedure? And my second, or actually not mine really, and particularly in Italy, I assume, with a very slow judiciary system. And second, since you guys are very prepared and up to speed, but since there is a big machine behind you, the ones that is actually, implementing the EUDR, or the guy at the customs, how do you proceed in such a short time? Because at the end, we have the summer in the middle. Europe is not really working during the summer. We start September. How do you train people then to, implement the legislation at the ports, or, behind their desk? Because I assume you guys are representing a big machine at the end.
Are you talking about officials or private companies and officials? Of course, we are a specific training program for such specific topics. But first of all, we need the IT system for the EUDR implemented and completed with possible fallback procedures and so on and so forth. And we need also to talk with our partners of the other member states in order to co-disseminate mutual experiences. We have to start working, because otherwise now it is useless now to talk about controls, how to implement. We have envisaged controls, okay? We have envisaged for 2026, based on risk analysis system, based on the risk assessment for each country's low risk, standard risk, high risk, and so on, for 7 commodities, 511 operators to be inspected. But this is based on the information provided by the Italian Customs Agency. And remember that, as said by now my German friend, we are talking about ex post controls, okay? Not ex ante. Controls after the put in the market of the product, or the trading, or the import, and so. So this means that we have to absolutely avoid any custom stopping. And this means that we have to check companies which have put on the market products, commodities, and so. So we need to avoid custom stopping, administrative burdens. We need to train our inspectors. We need to have to get the IT system performed and in place. But first of all, we need to start working.
Thank you. Thank you. Thank you, all of you, and also for being here. I have a joke, but back in Alliance, Germany, Italy, I understand.
I was born in Germany, so probably there is a spiritual
connection
between us.
Now, you said, Bartolomeo, I love that, because you spoke about being extremely pragmatic and work on it, but there are players that are already working on it. And here we have representative of these players. So we have a beautiful panel now with Ilenia Maitini, Sustainability Public Policy Director at Ferrero. And then we have Iliana Axiotiades, my Greek correct, from school was not very good. Secretary General of COSERIAL, and then we have Aileen Gordon, that is the Secretary General of European Coffee Federation. And it's great because you are already doing the dry runs or the tests, as or the trials, as you want to call them. And in some cases, we have companies that claim at least that they have achieved a full EUDR compliances. We have value chains that are demonstrating they are doing impressive work, and some value chains are behind. Within the same value chains, you have operators that are, let's say, at an advanced stage, and you have maybe smallholders that are in a way or could be left behind. So I will start with you, Ilenia, because I understand that as a company you are achieving impressive results, and maybe you want to explore them with us.
Thank you, Pietro, and thank you, the European Food Forum and MEP Fiocchi and Singer to having, first of all, organized this very important debate on EUDR. I'm very glad also hearing the conversation so far that we're having this discussion, because this is exactly what we need. We need conversations between operators, the authorities that are going to do the controls, but also the institutions, to make sure that the interpretation is correct and in line with the intention of the law, let's say. So first of all, maybe a quick word on Ferrero, on who we are. So as you may know, we are a global company, family-owned, operating in the chocolate domain, and we operate with global supply chains. So for us, deforestation is not something new. It's a risk that we have been tackling since a long time. Also, as part of the DNA of the company is really this approach to strong approach to traceability and to know where our raw materials come from. We have this mantra within our company, which is sacco conosciuto, which in Italian means basically know what's in the bag. And this was our founder, who profoundly believe on the fact that if you can only understand the full story of your supply chain if you know what's in the bag that you are buying. It's really within this spirit that we supported and embraced EUDR legislation when it was firstly discussed and then it came out, because we really see it's an important step forward towards increasing transparency, but also accountability, and ultimately also the sustainability of the supply chains involved. Is it easy? No. Absolutely not. It's challenging, even for a company like ours that has a long history of investing in strong traceability. So we do recognize the challenges in some sectors more than others, and we do recognize also the challenges in IT system and getting clarity. All of that has been already shared with us today. Nevertheless, we really strongly supported this legislation, and we still do today, even throughout all the very polarized debate in the last year and a half on the first delay, second delay, etc. We supported the regulation. We didn't want a delay, together also with many other peers in the sector, but also beyond our sector. Simply because for us, I think we all share, regardless of whether we wanted a delay or not, I think we all shared the objective of this regulation, right? And therefore, for us, the focus should not have been on the let's delay or we're not ready, etc., but really let's focus on implementation. Let's make it work. And this was really our belief. And how we can do that is really through engagement, and debates like this today are really, really helpful to share opinions. And so throughout the experience, obviously we had a cross-functional team inside the company reflecting on and asking us also as a public affairs many questions. How do I interpret this? How do I interpret that? And we also engaged a lot externally via our trade associations, where our partners, in asking many questions to the Commission.
Ilenia, maybe you want to explore a bit more this community of practice.
Exactly, that's exactly where I wanted to go, because when we started discussing also with our peers, we realized that we were not alone in having all these questions, right? And that also maybe the Commission had some of the answers, but then also the authorities have answers and all of us have answers. And so we really started looking at, okay, how can we make sure that we can make it work? How can we find solutions for these challenges? Because once you identify challenges, you need also to start debating on how to find solutions. And this is how the idea of the community of practice came about, together with other peers as part of the European Sustainable Supply Chain Coalition, which started as a COCO coalition a few years ago, and then embarked also other sectors and other companies and other actors. And we started engaging with the Commission, and in the end now we have this community of practice which has been established since a couple of months, but it's already advancing. And we are really seeing that there are very concrete, very tangible discussions. There are 12 competent authorities participating. There are representatives from the different sectors. And despite the fact that there is only a core group that, in order to ease the discussions, nevertheless, the community of practice is really open to everybody. It's reached over 1,000 members so far. So I would encourage anybody in this room who is not part of it to really register and engage, because there's a lot of debate happening there. And we are seeing that when you move the debate from political side to really concrete and technical, that's where the solutions start coming out. No, you were mentioning one solution on the IT. Let's have a backup plan. It's really things like this that help working towards the implementation, and this is what we are really looking forward, and we want to continue supporting. So for us, support was, or throughout the legislative proposal, was really supporting the intentions, but also supporting, identify the challenges together, and let's find a solution together. Let's make it work. So this was really the main spirit with which we embrace the EUDR regulation.
And you see results from this community campaign?
We're seeing results. So the first few meetings were really to identify challenges and establish where everybody is at and what are the common grounds. And now, for example, there's a next meeting, an in-person meeting of almost 2 days happening in Barcelona, in Spain, where all the members will gather together. And there they have many subgroups. Really, they will be working on legality, which documents we need to prove, and what we can prove and what we can't. There are small groups, for example, a subgroup on smallholders and data ownership, and how do we support also smallholders to come on board. There will be meetings with certifiers, for example, and certification schemes to understand, okay, could we have maybe an EUDR certification that can help also smaller companies coming on board. So all of these ideas are really being generated as we speak, and it's incredible to see how in a couple of months all these developments are emerging, and we really hope that now the exercise towards December 26 will be really like, let's not slow down the process, but let's make it work, and let's strengthen the readiness of the entire industry and the entire ecosystem, because it's readiness for competent authorities, for operators, for everyone.
Thank you very much, Ilenia, being here and bringing this experience. I will move to Ileana, that is the Secretary General of COSERIAL, please.
Thank you. I have a PowerPoint. Okay, thank you. I see it somewhere. Thank you. Okay, yeah, you can move forward with the slides. Thank you. So this is, I won't go in details, obviously, just to illustrate the fact that we present a broad range of traders. And what I think is very important is the number of companies, because people talk a lot about the ABCDs. ADM, Bunge, Cargill, Refuse, but a lot of very small traders, and this is where the big challenges begin here. We also have a good coverage geographically throughout the EU. Next slide. So this is again to illustrate. So wherever you see the COSERA logo, this is all the points across the food and feed supply chain where traders have a role to play. So it's both in terms of importing, but we also have a very strong presence within the EU. And I think it's important as well to say that we are importing a lot, and I'll come back to it, but we were very, very much supportive of European agriculture. Okay, it's very important I mean, we also make, let's say, people make a lot of money also by trading internally intra the EU. Next slide. So one point, and I was thinking as we were, you know, we've seen in the polarizing discussion that there was, oh, but some companies can do it, some sectors can do it, the others didn't do their job, they didn't do their homework, etc. And I would like to companies have been working on this. I mean, I remember I used to work for a company. And 2006, we were sitting then discussing, it was palm oil at the time, you know, what to do to avoid deforestation and so on. So, I mean, most companies, at least the large ones, did not wait for the deforestation regulation in order to do something on deforestation. So it's not that companies have not prepared. And again, I'll come back to it, but the way I like to say it is that everyone's ready, but people are not certain that they're going to be controlled for what they have prepared. You know, and then there's all these costs that I will discuss later. Next slide. So here I have two slides where I want to show the complexity of soy supply chains. Also to say that, I mean, if you imagine a large country as Brazil, who's not here today, but I mean, the US is the same in other countries as well, but Brazil is really the big challenge today because you have this huge country with truckers who often are, you know, entrepreneurs themselves, who take the best bid in order to transport the soy, come from all over the place, all put their soy in one spot. Then you have the train, everything goes because, you know, it's a commodity. The trains are filled. And they all go converge again, and you have this kind of convergence system that goes. And I have another slide as well that illustrates this next, which they all converge towards the ports. And what we've seen is that, so because here we're talking about separating kernels of soybeans. It is not easy. So that has required companies to make a lot of investments to build separate silos in the ports in order to separate the supply chains, etc., with a lot of challenges as well, because you take large countries, how do you control what's happening in the Amazon forest? I mean, realistically, right? But there are ports where this is not possible as well. So this is also excluding part, which maybe is not necessarily the areas where deforestation is taking place. And it's not a lack of will. This is, I mean, in Coseral, there are companies who trade several commodities, and they say that for some commodities, they figured it out. But there are some commodities like soy and palm oil where has been very difficult to figure it out. If I go to the next slide. So here I wanted to go to the focus of the issue, which is what are the issues we have with the current draft. So one was, and it was discussed, how are we supposed to know what law is applicable in every country at national, regional, local level? So, I mean, this was brought up, the repository is very, very important. And it's good because we went from a phase where we were told you would never get it to a phase where I remember in a meeting in a cabinet where I was told, well, you know what, it exists, but we cannot make it public because we are not certain it covers everything and we don't want to be held liable about it. So we made a lot of progress and this is good, but I thought I should repeat here that this is very, very important because of the risks that it represents. The other thing is the excessive cost that this is creating. And one thing, and we have this in Italy, and I'll come back to this, a lot of small traders. These small traders will not be able to import directly anymore. And one day we'll have a GAFAM situation, and who will you criticize? It will be the large traders who in reality had no, you know, they will find themselves alone in the market, but they had absolutely no responsibility in this happening. So by making this so costly from an administrative perspective, I mean, smaller traders, and I'm looking at you because a very specific example in my mind of a medium-sized trader in Italy, and we can discuss later, was explaining the money they spend on consultants because they don't have the capabilities inside. So we have also to take into account. This is the second thing we're very concerned about, and I'll come to recommended solutions. The third thing is legal and liability uncertainty. There are, and I'm not a specialist, but I'm told, and I believe all the people in companies who I work, there are contradictions in the regulations. There are loopholes in the regulations. And what everybody comes always up with is 4% of my turnover. And there was a company, and he said it publicly, so I can quote him. It's that Fetra is a Dutch medium-sized company who said, I can do it once. Second time, we're wiped out. So the risks are really, really big. And I'd like to come because he's Dutch and I thought about one thing. Today in the Netherlands, for a totally different reason, there are no imports of soybeans. So we're not crying wolf because at a certain point in time, something happens because of a legislation. And well, and in Italy, you have with soybeans as well at the moment, HB4, you have a big, big problem, right? You know, so no, what I want to say is it can happen that you get to a point like a country with such a big importer because they are the passage into Europe where there are no soybeans that are imported because of the risks, the financial risks involved. So this is also something that we would like you to look at. You know, the uncertainty and the legal liability is really too big. And Europe is not self-sufficient on soybeans, as you know, and also basically represent 8% of global soy trade. So we're not big enough to be able to tell people what they're going to do. The last thing is global inconsistency challenges. And I mean, the example I want to give here is Indonesia. Indonesia has said, our law forbids us from sharing data from our farmers. What is Europe going to do? Say we stop imports of palm oil from Indonesia. Is this a solution really? So these are things as well that we think we've raised them, by the way, year after year. And by the way, we were not for postponement. We were for amendment. We don't think the postponement solved anything today as we stand. So these are the issues we're seeing. And I'll go to the next slide if you may. Yeah.
You're right.
Sorry? Yeah. Okay. So, and I mean, Luisel, I guess you will circulate the slides. So yeah. All right. So basically, I would not, I mean, what we want to see is harmonization of legality. We want to the certification systems that exist today to be recognized. Why start all from scratch? When, as I say, companies and some associations like animal feed industry, etc., have done a lot of work. By the way, the animal feed has also put a number of the costs that it will bring. And we also would like to see some of the provisions that are today in the FAQs and the guidance documents to be integrated in the legislation. Because what we see as well is we have 2 member states here, but different member states are interpreted differently. So the companies who import in different ports can see that. So how do you, as an operator, can rely that the FAQ and the guidance that is interpreted differently by different control authorities are the ones that you can trust coming back to the legal liability. So these are the things that we think should be looked at. And I didn't mention IT system here because it's part of the challenge. One last comment, if I may. The boat that is waiting and it cannot unload has a cost itself in waiting. It's not justified. Thank you.
Thank you, Eliana. And again, apologies if I have to cut you off, but you mentioned Indonesia. I think we have Indonesia in the room. Maybe they want to add anything. Yes, exactly. Thank you. Because the rush was pushing me, but that's because I want to go to Eileen and give it enough time and also allow for enough time for a question and answer session. So Eileen Gordon, Secretary General, European Coffee Federation.
Thank you so much. I've also got a couple of slides. I'm not sure if they're available. If they are, super. But a big thank you once again to Mr. Singer. Pietro, Luisella, it's a great opportunity to be here and really happy to be able to showcase a little bit of what is happening with coffee, representing the European Coffee Federation that represents 90% of all coffee that's imported and manufactured in the EU. I would also like to share, like Ilania, the starting point for coffee. Where does coffee come from? Coffee doesn't grow in Europe, unfortunately, because the rule of thumb is where you've got good wine, you can't, unfortunately, grow coffee. And you can see it as a fact.
We had in Italy coffee. No, we.
You don't grow it. You have to grow it. So where do you grow coffee? Grow coffee in the coffee belt, which is between the two tropics. So what is the reality in these countries? Coffee is grown in over 50 producing countries where 85% of these farmers, 12.5 million farmers, are actually smallholder farmers with less than 2 hectares. In countries like Uganda, is actually what they're cultivating less than half a hectare. An interesting fact is that 70% of the people that are working on these farms are actually women. How do we buy our coffee? So 20% of the coffee that is brought in the world is through voluntary sustainability standards, rainforest, organic, for instance. 30% is brought through auction system or also through big cooperatives. So there is some degree of traceability, but the other 50%, the coffee that is brought from 6 million farmers, doesn't have any traceability per se. We're talking about small farms, half a hectare, that are selling in that system that Ilenia was referring to beforehand. In my next slide, what I would like to showcase is the fact that even though in Europe, 50% of our coffee is coming in from Brazil and from Vietnam, where there is a certain degree of traceability, there are some countries that represent a very small part of our inputs, but where coffee is very relevant to their economies. Burundi, as an example, 600 families depend on coffee. They only represent 0.2% of our inputs, but in turn, we represent 90% of their exports. So when we are told, well, don't worry about those geo-coordinates, don't worry about traceability, don't stock from countries like Burundi or Uganda, we say, no, we've got a huge moral responsibility. So it doesn't matter how hard it is, we are going to manage. So this is just a couple of other examples of where coffee has a very deep impact. In Uganda, 1.7 million people depend on coffee, and coffee is actually 14% of their foreign currency exchange. So just imagine the relevance that it has. In my next slide, what I would like to share is that above all, we do believe that EUDR is an opportunity. We talk a lot about challenges, but we do think it comes as an opportunity. Until now, all the European legislation was impacting directly our industry, our traders, but never the producing countries. So as from 2017, 2018, anticipating the coming of EUDR, we started reaching out to these countries, realizing that the impact was going to be way bigger for them than for us here in Europe. And I would really like to highlight that we talk a lot about simplification, but we have to bear in mind that because these smallholder farmers are not placing coffee directly in the EU, no simplification applies. We still have to geo-coordinate. We still have to ensure that traceability. In any case, it's been a great opportunity, and I really want to highlight this, to be able to engage much more with our producing countries, also with the Commission, competent authorities. So we really do believe that we've created a really big coffee community. In my next slide, we highlight a little bit what the challenges are. The original ones that we had from the very beginning was the geo-coordination of those 12.5 million farmers to ensure that nobody is left behind. Really complicated. The first thing we did, we reached out to the European Space Agency. That couldn't have been kinder. They sat with us. We were there in Prague at the headquarters. But unfortunately, they couldn't help us. And we said, my goodness, if USPA can't help us, who can? How are we going to geo-coordinate this? But we continued to plow through all the challenges. And now we must say that countries like Brazil have incredible geolocalization systems. But it really has been very dependent of what many producing countries have done. What is very important to note is that if you don't have an appropriate geo-coordinate from the start, all your due diligence exercise doesn't work. If you don't have that accuracy, that certainty, it doesn't matter what you do afterwards, it won't be valid, it won't be useful. So that is why for us, from the very, very early days, ensuring this geo-coordination was essential. Today, many countries have it, like Costa Rica, all under control, but in Africa, there is still a bit of a black hole there, and we are really working, our companies are really working to be able to ensure, as we said, that no one's left behind. The same applies to traceability. As you can see, because of the supply chain that we have in countries like Kenya as well, 4.5 million farms with these very small farms, how do we ensure this traceability, especially in places where there are big cooperatives as well? Brazil, 12,000 members has a cooperative. How can you include all these geo-coordinates in one container? Because coffee is a bean, is a little bit like your kernel. It really is a question, especially for commercial coffee, obviously not specialty coffee. We buy it in bulk. So tracing those beans is a big challenge for us. In my next slide, I would like to refer to the upcoming very concrete challenges that we have that are very similar to all the colleagues here. We really appreciate Germany and Italy, you coming today and how you talk about trying to align, trying to learn from one another with all these run tests, because for us, it's so important that there is harmonization in the implementation. Our companies, especially those that are operating in different markets, really require that certainty to be able to know that when they're bringing their coffee through the port of Barcelona, Trieste, Antwerp, Hamburg, they will have the same conditions, because otherwise we will end up, oh, I'm going to go through Italy because look, we've got a more practical, pragmatical approach. So for us, it's really important to be able to ensure that coffee can come in the same way in all or throughout Europe. The due diligence requirements, of course, that repository that you were mentioning before, really important as well. We really need to know with absolute certainty what we need to comply with, and we need everyone to be looking at it in the same way, because I think our companies, like everyone was mentioning, they are prepared to the best of their abilities. Now we need that certainty to be able to take that step. And soluble coffee is a great example. We are very happy to see it included. We really feel there was a loophole there in the system. So we really appreciate that our comments have been taken into consideration. It's included, but now we need the certainty that it will go through Parliament, through the Council, and we will have the guarantee that it's included. Because if it isn't, once again, it's a lot of investment that has been made, and it will be rendered useless, where it can be much more useful in really helping the sustainability of these producing countries. And last but not least, I won't go into it, the operational readiness, the information system as well, with all its challenges. It's evolved a lot. We're really happy to see that evolution, but it still needs to be a secure system, because we are uploading a lot of information. It can't fail, but just as my colleagues have shared, that would be our greatest concern. And in my last slide, it's something nice that is actually happening in Brussels between the 25th and the 27th of June. We've got World of Coffee, and we would like to invite you all to join us there in World of Coffee to learn a little bit more about coffee, because we really do believe that if regulators, when they're regulating, have a better understanding of the product or the commodity itself, it can really help. So therefore, we believe this is a great opportunity to join us with the producing countries that will be the stars there. So thank you so much for your attention.
Thank you, Eileen. Thank you, Eileen, for bringing some campaign into the debate. Jay, as a commission, you can bring the entire DGM to the meeting, provocation. Now, very quick, 10 minutes before leaving the final conclusion, Ms. Singer. So if we have any question for our three speakers. Yes. If there is any question, no question, one question there or comment from Indonesia.
Thank you so much, Peter, for the chance. Just want to support the colleague from Ferrero about the issue of data and geolocation or geo-coordinates. But first of all, for us, the EUDR still have some problems that we need to fix, which one of them is about the geolocation. And in this regard, it is correct to say that in our national regulation, we are forbidden to share sensitive data, unfortunately, and then including this data about geolocation. But however, we have engaged the Commission to discuss the mechanism of sharing data, which can guarantee that the data will not be misused or abused. And then, of course, we need to find another solution to that through what you said earlier about the fallback procedures. We are still trying to discuss this with the Commission, and then of course we will look forward for continuing the discussion. Thank you.
Thank you. Any comment or question? No? So I think now prevailing the will to go home, so I leave the floor. But it's been, I have to say, no further remark from me, but it's been a beautiful discussion, and I think a great opportunity. And thank you again to the forum for putting this together, to Jay and to all the speakers for being here. I still have more questions now, so we probably need a further forum in the next months. Mr. Fiocchi is gone, so we don't know whether he wants to postpone or not, or he has changed his mind. But we leave this as a bet for the future. So Ms. Singer, to you for the conclusion. Thank you.
Yes, thank you. Yes, thank you for today's very incredible discussion. I would like to thank all our speakers for the contributions, and of course the European Food Forum for making this exchange possible. Today's debate has shown very clearly that the implementation of the EUDR is not purely a technical question. It is a political, administrative, and economic challenge. And the EUDR has a clear objective to ensure that products placed on the EU market are not linked to deforestation. This objective remains important, and I will keep it very short, but let me conclude with one point. The fight against global deforestation is too important to be undermined by poor implementation. If the EUDR is to succeed, it must be both ambitious and workable. It must protect forests globally, but it must also respect the realities of the European producers, traders, processors, and forest owners. And that's the balance we need. Thank you again to all speakers, to the participants, and for the organizers. I look forward to continuing this discussion in the coming months. It is needed, and so thank you again for being here. Thank you.
Thanks. No. I leave the floor. No? Okay. So there is next events that I didn't read, so I take full responsibility. I will send emails of the next event.
It's going to be on the 14th of July, which is going to be done together with the Irish presidency on the International Day of Women in Farming. And then on the 1st of July, only for members of the European Food Forum, we will have our General Assembly, but we will have also discussion on the implementation of PPWR, which is another big topic. Okay, thank you.
Thank you, and apologize.
Thank
you. Better than me.